Therefore, I will first start with an explanation of the jurisprudence of the European Court of Human Rights regarding the prohibition of collective expulsion. My objective will be to highlight the guidelines that are being followed by the court with the view to identify whether there was a collective expulsion. These are not strict guidelines, of course. It's always a case-by-case analysis which is performed by the court. And I will then have a look at the jurisprudence of the European Court of Justice. So let's start with the jurisprudence of the European Court of Human Rights, knowing that at the very outset, there is not much within the European Convention on Human Rights to define what a collective expulsion is. Article 4 of Additional Protocol number 4 doesn't say much. It's very vague. It merely states that collective expulsion of aliens is prohibited. In a constant jurisprudence, the European Court of Human Rights has deduced from that article that in order to have a collective expulsion, two constitutive elements must be met. The first constitutive element is an expulsion of a group of aliens. The second constitutive element is the lack of reasonable and objective examination of the individual situation of each member of that group of aliens. With respect to the definition of the group of aliens, well, there are not strict criteria in the jurisprudence of the court. So the court doesn't require the group of aliens to be of a certain homogeneity. This is in stark contrast with the African Charter on Human Rights, which requests the group of aliens to be based on some constitutive criteria, such as the religion or the ethnicity. In the ND and NT versus Spain case, the European Court of Human Rights did not follow the argument of Spain, who argued that all those migrants that tried to cross the Spanish border from Morocco and were expelled, pushed back by the Spanish border guards, could not have been collectively expelled as they were too heterogeneous to be a group. So this was not followed by the chamber of the court, knowing that, and I've just learned it from Ms. Accardo, an appeal has been introduced and has been accepted by the Grand Chamber of the court in that case. So most of the jurisprudence of the European Court of Human Rights is focused on the second constitutive element, that is the lack of individual examination of the situation of each member of the group. How does the court check whether such individual examination took place? Well, the first element which the court is looking at is the motivation of the expulsion order. In a constant jurisprudence, the European Court of Human Rights emphasizes that the mere fact that the expulsion orders have the same motivation, that the mere fact that they have a stereotype motivation does not mean that a collective expulsion took place. However, when looking into the jurisprudence, one can also see that this is something that matters. And I might be tempted to argue that there is actually a presumption of collective expulsion in the jurisprudence of the court when expulsion orders are motivated in the same way. Another element which carries heavy weight in the jurisprudence of the court to check whether a collective expulsion took place are all the factual circumstances that surround the adoption and the implementation of the expulsion order. In Chonka versus Belgium, for instance, the court concluded that there was a collective expulsion because, among others, the authorities had made statements according to which they will expel Roma people out of the Belgian territory. So those political statements that were made were used by the court to conclude that a collective expulsion took place. In that case, there was also another element which was very important in the eyes of the court. And that other element is the fact that there were practical obstacles in accessing the court. So the applicants tried to introduce appeals against the expulsion orders, but it was made very difficult by the actions of the authorities. In another case, three other cases actually that concern the expulsion of Georgian nationals out of Russia, the court also heavily referred to the political context. And in that case, while the applicants had access to national courts, they could argue their case in front of the Russian courts, but the court concluded that the whole political context, the whole context just reveals that this control by the national court was mere window dressing. So the control exercised by the Russian national courts was so low that one cannot say that there was an individual examination of the situation of each applicant. Another factual circumstance which is very often taken into account by the court and which comes up a lot in the jurisprudence of the court, where the court concludes that there was no collective expulsion, is the fact that the expulsion order was adopted after the examination and the rejection of an asylum application on the ground. So in a lot of inadmissibility decision, the court mentions the fact that an asylum application was introduced, that it was examined on the grounds, and that it was rejected. And we have an example of that in the Sultani versus France case that concerns the expulsion of Afghan nationals via collective flights, and where the court said, well, they had an examination of their asylum application on the ground, so there was no collective expulsion, even though those Afghan nationals were expelled as a group. Another criteria which is very often used by the court, at least in the most recent jurisprudence, are the procedural guarantees that are being afforded to the aliens. An essential procedural guarantee, according to the court, is the identification of the concerned alien. In the Irsijama case, the Irsijama ruling that concerns the pushback of asylum seekers by Italian coast guards while they were on the sea. They were intercepted and pushed back to Libya. Well, in that case, the European Court of Human Rights attached heavy weight to the circumstance that there was not even an identification of the expelled alien. So the identification of the alien to be expelled is a very essential procedural guarantee. It's a minimal procedural guarantee that guarantees that there was no collective expulsion. In some cases, however, the court also emphasized that no identification took place because of the acts of the alien itself. And we have an example of that in Dritsas versus Italy, which concerns Greek militants who were arrested and pushed back at the Italian border while trying to cross the Italian border to participate to a demonstration. Well, in that case, they were not identified, but the European Court of Human Rights said that it was because of their own wrongdoing. They tried to conceal their identity. So the state have an obligation of mean to identify the aliens before expelling them, but they don't have an obligation of results. Another element that comes very much forward in the jurisprudence of the European Court of Human Rights concerns the access to a procedure. In Irsijama, also, the European Court of Human Rights emphasized that it is essential to allow the aliens that you have intercepted to access to a certain procedure which will be fair because they will have the opportunity to present their claims, and those claims will be examined in an appropriate manner. Now, the court doesn't say much about the quality of that procedure. In Claifia, the Grand Chamber of the court considered that one cannot deduce from the prohibition of collective expulsion that every alien has the right to be interviewed during a personal interview. So in Claifia, the Grand Chamber overruled the ruling of the chamber by considering that there is no strict obligation to interview the alien before sending him back. So there is an obligation to allow him to access the procedure, but the court doesn't have strict guidelines with respect to the quality of that procedure, at least under Article 4 of Additional Protocol number 4. In ND and NT, the court emphasized again the need to access to a procedure, but this case is actually now being reviewed by the Grand Chamber of the European Court of Human Rights, and we'll see what the Grand Chamber has to say about that. So to summarize very quickly the jurisprudence of the European Court of Human Rights on collective expulsion, one can notice that in the very recent jurisprudence there is a greater emphasis that is being put on the issue of the access to the procedures. So the European Court of Human Rights seems to be looking more and more at procedural guarantees, but that at this stage there is still not much about what this procedure should be. So the court has moved from an earlier jurisprudence where the political context and the factual elements were very important to another line of jurisprudence where procedural guarantees have a very important weight. Now the question is, of course, what are these procedural guarantees. And we don't have much jurisprudence under Article 4 of the Additional Protocol number 4. We have more jurisprudence under Article 3, of course, in Article 13. But this leads us to another question. Does EU law say more about these procedural guarantees? Is there, under EU law, more indication as to what kind of procedural guarantees shall be afforded to aliens? Is there, under EU law, more indication as to what kind of review must be performed so that one can say that the applicant had the opportunity to present his individual claim? Under the EU Charter of Fundamental Rights, there is, of course, Article 19, which takes over the prohibition on collective expulsion, but doesn't say much more than the European Convention of Human Rights, nor does the European Court of Justice. But there is also Article 41 of the EU Charter of Fundamental Rights. Article 41 of the EU Charter of Fundamental Rights establishes the right to a good administration. And that right to good administration is based on two components. It's based on the right to be heard, and it's based on the duty to give reasons. You have the right, according to that right to good administration, to be heard on your claim, and the administration, when rejecting your claim, must state why. And the duty to give reasons is, of course, of particular importance, because that's what allows a judicial review in accordance with Article 47 of the Charter. Now, Article 41 is not applicable to the member states. Article 41 only applies to the EU institutions and agencies. But the European Court of Justice has already ruled that with respect to one of the components of the right to good administration, the right to be heard, well, that component merely expresses a general principle of EU law to the extent that it is indeed applicable to the member states. So the European Court of Justice has interpreted Article 41, or at least one of its components, as being applicable to the member states. And this leads to quite a lot of jurisprudence of the European Court of Justice that substantiates the right to be heard, even though the kind of substance which we get around the right to be heard is not that high in the jurisprudence of the European Court of Justice. In the M2 case that was adopted after the Clarifia ruling, for instance, the European Court of Justice ruled that the right to be heard does not imply the right to a personal interview in every circumstances. So the European Court of Justice says, well, the right to be heard might imply the right to a personal interview, but there might be some circumstances where you already had the opportunity in a previous procedure to put forward your arguments, and then in that kind of circumstance, you cannot claim the right to have a personal interview again. Aside to these procedural aspects, the European Court of Justice also gives some substance to the individualization requirement. So you have a lot of cases in the jurisprudence of the European Court of Justice in the field of asylum and migration that rest on the individualization requirement to come up with a particular solution. And in asylum, we have an example with this general requirement of an individual assessment of the asylum application. I think it's quite obvious, the individual assessment of the asylum application as it is stated by the directives themselves, but still it is something noteworthy, certainly as one is speaking of Article 15C of the Qualification Directive. So the individualization requirement is requested with respect to application with the view to get recognized as a refugee, but that's makes sense. That's in line with the 1951 Refugee Convention, but it's also requested with respect to Article 15C of the Qualification Directive, which affords subsidiary protection to anyone who is fleeing a situation of indiscriminate violence. And it is quite interesting, I believe, that the European Court of Justice fell back on the individualization requirement to establish what has been called the El Ghafaji scale, to consider that there might be situations where the violence is not as indiscriminate enough to consider that everyone is being targeted by it, but that some people might still be targeted. And we have a very concrete example of that in the recent jurisprudence of the Council of Alien Law Litigation in Belgium regarding Baghdad. The General Assembly of the Council has concluded that Article 15C is not automatically applicable to people and have fled Baghdad, but that an individual assessment of the facts must always be performed, and that individual assessment may lead to the conclusion that Article 15C is applicable to that specific applicant, given his individual profile. That individualization requirement also comes up in the jurisprudence of the European Court of Justice concerning the personal conduct of the asylum seeker and the exclusion of the refugee status. So in various cases, the European Court of Justice has emphasized the need to always examine the personal conduct of the applicant. And we have that in the B and D case that concern membership to a terrorist organization, while the court said you cannot automatically exclude an asylum seeker on the ground that he is a member of a terrorist organization. You must always look at his own personal conduct. In Unani, of course, the court has made some precision, and I say that this personal conduct might be the fact that you are a member of a terrorist organization, but still there is no automaticity between this question of being a member of a terrorist organization and the exclusion of the refugee status. There is always a need of individualization. In Dublin transfers as well, the individualization requirement has come up. The European Court of Justice has ruled in its previous jurisprudence that was heavily contested, and I'm referring here, among others, to the Abdullahi case, that the Dublin transfer may not take place if there are systemic deficiencies in the asylum system of the receiving member state. This has led to controversies as to whether one could invoke a risk of violation of human rights in case of a transfer to the responsible member state that will be based on the personal profile of the asylum seeker. Well, in CK, quite recently, the European Court of Justice has provided us with a positive answer. So it might be, indeed, that given to the individual profile of the asylum seeker, a Dublin transfer might not be compatible with the EU Charter of Fundamental Rights to the extent that it shall be suspended. So again, this individualization requirement that was set aside by the court in its earlier jurisprudence on Dublin is now being used again by the European Court of Justice. Outside of asylum, the individualization requirement has also come up with respect to the right to family reunification. Well, there is first the well-known, I think, Shakrun case, where the European Court of Justice has adjudicated that one cannot require a certain amount of, a fixed amount of revenues to be possessed by the sponsor. So if someone is willing to bring his spouse or whatever, you cannot require from him that he has a fixed amount of revenue. You can have an amount of revenue which is in your own national legislation, but this is but a reference amount. There is always a need to make an individual assessment of the case. So for instance, you have national jurisprudence that will say, well, you don't have that reference amount, you don't earn as much as what is required by the law, but you're the owner of your house, so you have less cost, and we can consider that indeed you fulfill the condition for family reunification. So again, it cannot be rejected on the basis of a fixed amount, but individualization is required. Thank you. Another example of that concerns integration tests, which were also used by some member states with the view to reject a claim to family reunification. And here again, the European Court of Justice called the member states on performing an individual examination of all the specific circumstances of the case. And so to conclude, what can we say about individualization? What are the concrete requirements of individualization as they stem out of the jurisprudence of the European Court of Human Rights and the European Court of Justice? Well, one can say that individualization implies minimal procedural requirements. And those minimal procedural requirements can be found in the jurisprudence of the European Court of Human Rights, which consecrates the obligation to identify the alien and to grant him access to a fair procedure. The court doesn't say much about what a fair procedure is under Article 4, Additional Protocol number 4. It simply states that the alien must have the opportunity to present his or her claims, and that these claims must be examined appropriately. We have some precisions, but not much, that come out of EU law. EU law that states through the right to good administration that to be fair, a procedure must include the right to be heard, which does not imply automatically and in all circumstances the right to a personal interview, but also the duty to give reasons. So there might be an additional requirement for the state to always state why in the individual circumstances that concern that case, there is an expulsion order that must be adopted. Aside to those minimal procedural requirements, there are also minimal substantial requirements that stem out of the jurisprudence of the European Court of Justice in the field of asylum and migration law. And I will say that this minimal substantial requirement is simply the requirement to take all relevant facts into account. This implies, in terms of asylum, to take into account the personal profile of the asylum seeker before expelling him back to his home country or to the responsible member state by application of the Dublin regulation. And this implies, in the field of migration, to apply the proportionality principle. In the field of migration, the individualization requirement finds its expression in the proportionality requirement. So I will be tempted to say that actually the individualization requirement is nothing more than a very broad and general principle that finds its expression through other principles, which are the principle of due procedure, which are the principle of a procedure which is fair on the one hand, and the principle that govern the examination of an asylum application and the proportionality principle on the other hand. Thank you.